Hello, everyone, and welcome to today's training. We're so excited to have you, and today's training focus is compliance with facility-initiated transfer and discharge requirements. And we have a special uh, guest today, our expert, and we'll be kind of walking through and doing introductions after these first couple housekeeping slides. So the first thing I'd like to do for those of you that have joined and you're very familiar with Team TSI, while all the craziness was happening in the background of 2020s, we had some wonderful things happening for us, and we were purchased by Strategic Healthcare Programs in June of 2020. And for those of you that are not familiar with TSI or SHP, I really would encourage you to go to the SHP website and look at the amazing solutions that they have for health, home health, and hospice. And now by acquiring Team TSI, we're providing that same wonderful information and analytics for nursing homes. So what you're seeing on the slide is the transition that our customers are going to be seeing. It's the Team TSI logo will slowly fade away and you'll start to see that SHP logo. And then the IntelliLogix, which is our analytics portal, is absolutely staying the same. You're simply going to see some little facelift of colors with the yellow in the IntelliLogix logo. Same support, same quality, same commitment, powerful team, now all under SHP. So the next slide we're going to look at is how to ask a question in the GoToWebinar panel. So for those of you that are experts, obviously you know how to do this, but those of you that are brand new, just take a second to look at your GoToWebinar panel and find the line that has questions. And when you find that, click on that little line and it will open up and look like the number 2 example. And when you see that, you're going to type your question where it says enter a question for staff. When you hit send, it will pop up in that questions pane, and we have a whole team of experts that's available answering questions throughout today's training. Another tip here is we also have loaded a fabulous handout that our expert has created really for you and to help you with this topic. So please make sure that in that GoToWebinar panel, you look to see what that handout is, and you can click and download it on the GoToWebinar panel. With that, I'd like to make a couple introductions. So first of all, we have a team of experts, even not listed here on the slide. So again, please feel free to reach out, and we've got a number of people on today. But we're led by Greg Seipel, our VP of Clinical Informatics. If you're not familiar with him, he is just really one of our experts that has been in many of your shoes in many positions for a very long time and has brought that wisdom to us here, and you'll be able to hear some of his information that he can share with you and really relate to some of the things that are happening in the industry. And we also have Hugh Heaton, which you may recognize from years and years in the industry. And he's one of our favorite experts that just adds so much to what we're doing here at Team TSI, and he'll be our guest speaker today. My name is Dahlia Croft. Along with the team that's on today, we're all going to be here to assist you with questions and answers throughout today's training. With that, I want to go ahead and turn it over to Greg so he can walk us through today's goals. Hi, Greg.
Hi, thanks so much, Dahlia, and thank you for all the kind words. I have to send you a check, I think, or something. Thank you so much to everybody for joining us and coming on board to hear this information being shared specifically about the transfer and discharge requirements. We have some goals for our session today, and of course, Hugh Heaton is going to be the driver beyond the majority of this, but we all sort of saw that notice that came out from the OIG that, initiating investigations into the facility discharge process, especially transfer and discharge. And, nobody loves anything more than an Office of the Inspector General and investigation into how discharge and transfers were handled during the height of the pandemic and the public health emergency. So for this goal, Hugh's going to go through and explaining what some of the scope of that investigation is. We're going to define what a facility-initiated discharge actually is based on the regulatory definition and criteria. And of course, we're going to spend quite a bit amount of time reviewing and discussing the survey tags that are relevant to transfers and discharge, specifically two tags that carry basically the most weight for facility responsibility and requirements, centered around documentation as well. We're also going to look at the survey team's use of the discharge and hospitalization critical element pathways and our care area probes. And of course, Hugh has been wonderful in putting together some tools and some handouts that you've already have access to that kind of help guide you through what the regulatory requirements are and the information relevant to ensuring you're compliant with this practice. And of course, have to review the current CMS waivers that are applying to facility transfers and discharges. There's very much specificity to those waivers. It's not a blanket that qualifies for all of that. And unfortunately, when you're dealing with an OIG investigation, so much of that is Monday morning quarterback type of stuff. They're looking at past documentation, and oftentimes it's being looked at and viewed under the new knowledge that we have, not basically the knowledge that was present at the time. What really protects you in that is your documentation. And Hugh's going to kind of go through all of those requirements as well. If you're not familiar with the name Hugh Heaton, if you've been in the industry for a significant amount of time, or even a short amount of time, you probably are. You may know it more from the Heaton manuals. You've written countless policies and procedures and guidelines, not only for operational, but infection control and nursing practice and procedure. Basically kind of a giant in the industry, very well recognized. Experience going back into the 70s, and I'm not trying to date you, Hugh, and make you feel old, but it's just the wealth of knowledge that you bring to the topic and all of the hard work that you put into what we do, and being able to provide this information in this context and share the benefit of your knowledge and the handouts as well. Just I really appreciate that. So without any further ado, I'm going to turn this over to Hugh, and thank you so much.
Well, thank you, Greg and Dahlia, and good afternoon, everyone. This is a jam-packed session. First thing I wanted to spend just a couple of minutes on, and I need to make a little adjustment here, is to just go through the handouts with you. And as Dahlia mentioned, they are on the webinar. I would encourage you to download those, because the information that we provide in the slides address all of this information. One of the things that I enjoy working with Team TSI about is they don't want just to provide you with a webinar filled with slides. What we want to do is provide you with information that is helpful to you in determining, am I in compliance with facility initiated transfers and discharges, or am I in compliance with just the transfer and discharge requirements as a whole? So the first handout you have is going to be the session outline, and this is just a slide of, I'll just show you one very quickly. Let me get here. This is a 91-page document, by the way. So it's just going to go through and show you the same slides that I'm going to show through the session, but it has note pages. So if you want to take the slides and use them in teaching your staff, you don't have to recreate them. They will be there for you. The second handout, and this is all one document, by the way, so they're all together, and you can separate them, of course. But the second one is your survey tags relevant to facility-initiated transfers and discharges, and we're going to focus a lot of the session there. But let me just look at what all handout number 2 contains. It's all of the survey tag numbers. That these tags were initially became effective November 28, 2017, and you will find that this particular handout has the current tag number, but also the old tag number. And that's important because some of the survey process and looking at previous survey history, they're going to go back and look at the old tags as well. So this will provide you with information there. So all of the tag numbers are here that we're going to look at, as well as the psychosocial outcome severity guide This document will be used in determining any psychological outcomes that may have affected the resident because of a transfer or discharge. So they look at this document. The handout number 3 is the care area pathways and the care area probes. These are the exact documents that the survey team will use, and when they're in the facility conducting the transfer or discharge section of a survey. But what they do is, this is on their computer. And if they have identified a resident that they want to look at, or your facility requirements concerning discharge, they're going to use this critical element pathway. Under the survey process, they will have to answer all of these questions before they can come out of the survey process on their computer. So these are the exact questions, the exact things that the survey teams are going to use. And there's 2 of them. There is the discharge critical element pathway and the hospitalization critical element pathway. And then the care area probes that we will look at. And we will look at each one of these documents. The 4th handout is your waivers that applies specifically to the transfer and discharge. And as Greg mentioned, there are specific requirements. The waivers does not eliminate all the requirements within these survey tag numbers. They're very specific as to what is waived, and we will look at that. The last handout is handout number 5, which is S&C letter 1808, which was released in 2017, but it's still effective. And this is what the survey guidelines of how CMS is going to investigate, and it provides a great deal of information. This is the actual CMS letter, and so as we go through the session, all of these handouts will be addressed. So if you, in using the slide material, you may want to download this so you will have access to look at what the survey tags are, and etc. So I would encourage you to download it and use it as you're beginning to go through, determine how compliant you are. So Greg mentioned the OIG investigation process. What prompted that is the number of complaints received by Ombudsman and CMS, and the number of media reports highlighting the rise in nursing home evictions. What's taken place is that in November of last year, OIG released this document that they are going to investigate this criteria. And what they're looking for is the extent to which the survey agencies, the state ombudsman, and CMS are addressing facility-initiated discharges, especially now that we have the pandemic and COVID, and how you're handling those. And to complement this work, the OIG will examine the extent to which nursing homes meet CMS requirements for facility-initiated discharges. And of course, we just looked at S&C letter 1808, which outlines the process. Now, in these documents, Greg and I were discussing it earlier this morning. The OIG is probably going to be looking at past history of how did you handle it, while CMS is looking at how are you addressing it today, your policies, your procedures, and etc. But the way that it's going to work, if a state survey identifies any issues with transfer or discharges, especially facility-initiated transfers and discharges, the state is instructed to provide that information to the CMS regional office. All of these issues, all cases involving a facility-initiated discharge, will be forwarded to the CMS regional office, and they will investigate that, not the state. They will do all of the follow-up, and they're going to be basing it primarily on a couple of three factors. One, where was that person discharged to or transferred to? Was it in a questionable or unsafe setting? How many residents are remaining in the hospital after you transfer them, and is this a facility pattern? So they're going to be looking at those kind of things. Last Friday, CMS released its 2021 priority survey. One of the criteria that they addressed that they will be looking at for this coming year is transfers and discharge. So we want to take a look at that. I'm not going to spend a lot of time here. These are one of the things that you look at is what is a facility-initiated transfer or discharge. According to the regulations, it's defined as a transfer or discharge which the resident objects to did not originate through a resident's verbal or written request and is not in alignment with the resident's stated goals for care and preferences. All of these definitions are addressed in your handouts in these tag numbers. Transfer and discharge. You've seen these definitions hundreds of times, so I won't spend a lot of time there because I want to look at a lot of some of the tags that we really need to focus on. So these are here what a discharge refers to. So now we want to look at the compliance requirements. And the first thing we want to look at are the tag numbers. These are the tag numbers that apply specifically to transfer and discharge requirements. 622, your transfer and discharge requirements. 623, notice before transfer. 624 is preparation for the transfer or discharge. Notice of bed hold policy. And you are familiar with all of these. Permitting residents to return to the facility, discharge planning, and facility and discharge summary. But our session today, even though we're going to look at some of these, we're going to focus on these two tags because these two tags, 622 and 623, are specific to facility-initiated transfers. Some other the tags that you want to look at are these tags, 560, 620, 637, and these tags. But I want to point out two tags, 637 and 838. If the transfer is based on a significant change, they're looking to determine, did you do a comprehensive assessment after the significant change? So they're going to look at that. But one of the primary tags they will look at is this tag, 838, facility assessment. And the reason for that is that you're required to determine your capacity and capability to care for the residents that you admit. So what the survey team is looking for is, are you accepting residents that you cannot care for or that's not identified in your facility assessment? Are you taking resident types that you can't take care of? Now, remember, there's some waivers on that, but this is one of the tags they are beginning to look at, is what's in your facility assessment. So I would encourage you to take a look at your facility assessment. Does it identify the types of residents that's in your facility? So let's start with tag number 622, transfer and discharge requirements. This tag applies only to discharges and transfers that are initiated by the facility, not by the resident. The information that must be provided to the receiving facility applies to both facility and initiated and resident initiated transfers, the type of documentation that you provide to them. This tag limits and it specifies the limited conditions under which you may initiate a transfer or discharge, the documentation that must be included in the medical record, and who's responsible for making the documentation, and we'll review that. It limits the circumstances under which you can initiate the transfer, thus protecting the residents from involuntary discharge, and that's really a major issue that they're looking at. So let's look at the facility, that's what's permitted, facility-initiated transfers and discharges. And there are 6 of them. The discharge is necessary for the resident's welfare, and the facility cannot meet the resident's needs. And all of these, you have, if you've gone through the regulations, you're familiar with this information. It just has a different spin on it now that we have the COVID and we have some waivers that affect some of this. The resident's health has improved sufficiently so that the resident is no longer needs the care. The resident's clinical or behavioral status endangers the safety of individuals in the facility. And these 3, what the survey team is looking for when they're evaluating, was it a facility initiated, was it a permitted discharge or transfer? They're looking at, did you fully evaluate the resident, and did you base the discharge on the resident's status at the time of transfer? So what they're looking for is past history. Why did you transfer them now? Why did you discharge them? So these first 3, they're going to be looking at documentation, and we'll look at that. Number 4, the resident's clinical or behavioral status otherwise endangers the health of the individuals in the facility. With numbers 3 and 4, they're looking at major documentation, especially provided by the attending physician, or in some cases, it doesn't have to be the attending physician. It can be a physician or one who is a nurse practitioner or physician assistant in accordance with how your state may accept that. Number 5 is the resident has failed after reasonable appropriate notice to pay. We've dealt with that for years. And if the facility ceases to operate. But these 4 are the ones that we want to focus on in this particular session. So emergency transfers to acute care. Residents who are sent emergently to the hospital are considered facility-initiated transfers because the resident's return is generally expected. Residents who are sent to the emergency room must be permitted to return to the facility unless the resident meets one of the criteria under which the facility can initiate discharge, and that's the 6 reasons that we just looked at. In a situation where the facility initiates discharge while the resident is in the hospital following an emergency transfer, the facility must have evidence that the resident's status is not based on the condition at the time of transfer and discharge and meets one of the criteria at F622, and that's the one we just looked at. How about refusal of care or treatment? A resident's declination of treatment does not constitute grounds for discharge unless the facility is unable to meet the needs of the resident or protect the health and safety of others. But this one is critical here. The facility must be able to demonstrate that the resident or the representative received information regarding the risk of refusal for treatment. And you must conduct an assessment to determine if the care plan revisions would allow, it's critical, would allow the facility to meet the resident's needs or protect the health and safety of others. So this would be a significant change, for example. Another tag number that you may want to look at looking at this particular criteria would be tag number 578, which deals with the resident's right to refuse treatment of care. Discharges pending appeal. When a resident chooses to appeal the discharge, the facility may not discharge the resident while the appeal is pending. If the resident's initial Medicaid application is denied but appealed, the resident is not considered to be in a non-payment status. Thus, an appeal suspends a finding of non-payment. So, your state appeal procedures, you certainly would need to want to look at those in light of that particular requirement. If the resident appeals his or her discharge while in a hospital, the facilities must allow the resident to return pending their appeal, unless there is evidence that the facility cannot meet the resident's needs or the resident's return would pose a danger to the health and safety of residents in the facility. But this is a critical component of this particular requirement. If there are concerns related to a facility's determination that it cannot meet a resident's needs, surveyors will assess whether the facility has admitted residents with similar needs. Be sure that you're looking at that because that's going to be part of the OIG's investigative process. That's going to be a part of looking at your facility assessment. So, have you had residents with these type situations before, and did you keep them? So that is a critical statement right there. And that comes right out of the regulations, by the way, 622. So let's look at the required documentation. The medical record must show documentation of the basis for the transfer. The documentation must be made before or as close as possible to the actual time of transfer or discharge. For transfers or discharges relative to the facility not being able to provide the necessary care or the resident no longer needs the care, the physician must document information about the basis, and this is for the resident's physician. This is what they're looking for. For transfers or discharges relative to the facility's inability to meet the resident's needs, the documentation made by the resident's physician must include the specific resident needs the facility cannot meet. Specific. The facility efforts to meet those needs. All of that's got to be in your medical record. And the specific services the receiving facility will provide to meet the needs of the resident which cannot be met at the facility. So these three components here, the documentation is critical to making sure that you're remaining in compliance with facility-initiated transfers and discharge. Remember, SAT Tag 622 deals with facility-initiated transfers and discharges. So I would encourage you to look at your medical records for any facility-initiated discharge. Does it meet these three criteria? In circumstances where the transfer or discharge is based on the safety and health of other individuals, documentation regarding the reason for the transfer must be provided by a physician, but not necessarily the attending physician. Documentation of the transfer may be completed by a non-physician practitioner in accordance with state law. So your documentation is critical in making sure that when the OIG or the CMS or state surveyors are coming in, what I was listening to a session this morning from the state of Nebraska, from the state survey agency, along with the Nebraska Healthcare Association. And one of the things that the surveyors indicated is that they are now reestablishing the standard survey process. They're going back to the regular survey process because all of the COVID-19 and all of the criteria has been incorporated into the survey process. All of these forms that you're looking at, they have been incorporated into that. So they're looking at it. But one of the statements they indicated was that CMS is doing the follow-ups. And I thought that was interesting. I'm not sure if they're following up on just transfers and discharges or any survey or focused infection control, but they indicated that CMS is doing the follow-up surveys. So the investigative procedure to determine if you're in compliance with 622 include this. They are instructed to briefly review the most recent assessment, comprehensive assessment, the care plan, the progress notes, and orders to identify the basis for the transfer or discharge. If you remember, we talked about that the discharge and the transfer is not based on the current. For some of the 6 reasons, they're looking at the medical record and they're looking at the assessments. During the review, surveyors are to identify the extent to which the facility has developed and implemented interventions to avoid transferring or discharging the resident in accordance with their needs or goals. So they're looking at that. Remember, one of the things that we just mentioned was, have you cared for residents with similar circumstances in the past? And so they're looking at that information. It's used to guide the observations and the interviews in order to investigate any identified concerns. And the other, that's your critical element pathways and your care area probes. They are instructed to observe for visual cues for psychosocial distress and harm. So they're looking at, did this cause anxiety, depression? They're looking at those psychosocial aspects, and they're using the psychosocial severity guide, and it's in handout number 2. So you may want to look at those. There are specific tags within that document as well, and a couple of those tags are 660 and 661, which deals with your discharge plan and your discharge program. So tag 623, which deals with notice requirements before and upon transfer or discharge. This requirement only applies to facility-initiated transfers and discharges. It does not apply to resident-initiated transfers and discharges. So tag 622 and 623 only apply to facility-initiated transfers and discharges. The review will address the requirements to send a notice in situations where the facility initiates a transfer, including discharges that occur while the resident remains in the hospital and after emergency transfer. Whether or not a resident agrees with the decision, the requirements at 623 apply. The resident may agree to do this, but if it's facility initiated, this notice has to be applied when the facility initiates the transfer or discharge. So let's look at the notice. The facility must notify the resident or the representative and the reasons for the move in writing and in a language and manner they understand. I'm not sure how you record that, but one of the requirements is that information be in the medical record, as we'll see that. Additionally, the facility must send a copy of the notice to the state ombudsman. You're familiar with that. You've been doing that for years. The notice must occur before or as close to the actual time. The medical record must contain evidence that the notice was sent to the ombudsman. If you're not doing that, go back and make sure that your record does identify that you have recorded in the medical record somewhere that it was sent and the date that it was sent. In situations where the facility has decided to discharge the resident while the resident is still hospitalized, the notice must be, you must send a notice of discharge to the resident, to the state ombudsman, and I'm sure you're familiar with that as well. For any other types of facility-initiated discharges, the facility must provide the notice to the resident or the representative and a copy to the state long-term care ombudsman 30 days prior to the discharge or as soon as possible. The copy of the notice must be sent at the same time that the notice is provided to the resident and resident representative. So that's important as well. So let's look at emergency transfers. When a resident is temporarily transferred on an emergency basis to an acute care facility, this is considered to be a facility-initiated transfer, and a notice of transfer must be provided to the resident and the representative as soon as practical, according to the timing of notice requirements. And we're going to look at these in the waivers. Some of this information has been waived. Copies of notices for emergency transfers must also be sent to the ombudsman, and that has been waived. So what's in the contents of the notice, and you've seen this so many times, the specific reason for the transfer or discharge, which those specific reasons must meet the requirements at F622, the effective date of the transfer or the discharge, the location to which the resident is to be transferred or discharged. And by the way, if at the last moment or something, let's say you're planning to move the resident and you're going to move them to a particular location, and that location changes, then the timing of the notice begins when the location was changed, the date that you were, say it was a week later, then the notice time begins from that date, not from this date when it was the effective date of the transfer, because if it changes, and sometimes it does, but you have to provide them with a new notice. It has to be an entirely new notice because it's a different location. An explanation of the right to appeal, the name and address of the state entity which receives the hearing request, and you have all of this information in your admission packet. But just to go over it, but especially to emphasize, especially if number 2 and 3 change, then it requires a new notice. The timing of the notice. Now, generally, and we see this notice must be provided at least 30 days prior to the transfer. But this information is waived. Exceptions apply when the transfer or discharge is effected because the resident's welfare is at risk and the needs cannot be met in the facility, or the health and safety of others are endangered. In these cases, the notice must be provided as soon as practical, and then you have to notify the ombudsman, and you don't have to send that particular notice to the ombudsman within that period of time. It can be sent on a monthly basis, for example, or you can send it when you send the emergency notice with others as well. The preparation for safe and orderly transfer or discharge. Now, this is not a notice requirement. This requirement only deals with preparing the resident for the transfer or the discharge. It has nothing to do with the notice requirements. It addresses the immediate orientation and preparation necessary for the transfer, because the resident or immediate discharge were complete, and this is where a discharge plan is not required. This is an emergency transfer where you're anticipating that resident to return to the facility. Sufficient preparation and orientation means the facility informs the resident why they are leaving the facility, where they're going, and takes steps under its control to minimize the anxiety. That is your psychosocial outcome severity guide that I discussed. So you want to take a look at that. You must orient and prepare the resident regarding the transfer in a form and a manner that the resident can understand. The form and manner of this orientation and preparation must take into consideration factors that may affect the resident's ability to understand, such as educational level, language or communication barriers, and physical and mental impairments. There is a rule, another regulation that the facility has to remain in compliance with, and that's Section 1557 of the Affordable Care Act. And what that regulation deals with is providing information in a language that the facility, that the resident or the representative understands. So what they're looking for is, how did you notify them? How did you prepare them? Did you provide any type of written information? Did they understand it? Because the next one is this one. The facility must document this orientation in the medical record, including the resident's understanding of the transfer or discharge. I'm not sure how you do that. I'm not sure, how would you know whether they understand it or not? I struggle with that, but that's one of the requirements, that the resident understand it. They can sign a document that they understand it, of course, but here again, it goes back to Section 1557 of the Affordable Care Act. What type of information did you provide, and at what level did you provide it at? So this is the intent and definition of 625. This deals with the bed hold policy, and we've been dealing with this particular requirement for ages. But it's part of the discharge and transfer requirements, and these are the things that the survey team will be looking for. The intent of 625 is to ensure that the residents are made aware of the bed hold and reserve payment policy before and upon transfer to a hospital, or when taking therapeutic leave of absence. Nothing new there. The bed hold is defined as holding or reserving a resident's bed while the resident is absent from the facility. Nothing new with those definitions. Reserve bed payment. Payments made by a state to the facility to hold a bed during a resident's temporary absence from the facility. What they're looking for is, not only do you have to have a reserve bed payment policy and bed hold policy for Medicaid, it also has to incorporate the reserve bed payment or bed hold policy for all residents, regardless of their payment method. And then therapeutic leave is defined as absences for purposes other than required hospitalization. So your notice requirements: you must have policies that address holding a resident's bed during periods of absences. We know that. You must provide written information about these policies to the residents prior to and upon transfer of the absences. The provisions require facilities to issue 2 notices. I have talked with some facilities that were not aware that they had to do 2 notices. And the first notice would be given well in advance, and most of the time when I was administrator, we did that upon admission. That information was in the admission packet. If that information changed, we had to update that information and provide that as well. The second notice must be provided to the resident and the representative at the time of transfer or in case of emergency within 24 hours. Permitting the resident return to the facility, tag number 626. I think this is where, especially with the COVID discharges and transfers, I think this is where we will probably have some of the greatest issues within meeting these requirements, is permitting the residents to return. And listening to that session this morning, there was a lot of questions about hospitals sending back residents with COVID and the facility wanting to test, and they wanted to refuse all of those transfers back to the facility. So this is becoming a major issue. is to ensure that the facilities develop and implement policies that address bed hold and return to the facility for all residents. Specifically, residents who are hospitalized or on therapeutic leave are allowed to return back to the facility if they still meet the service requirements. In situations where the facility intends to discharge the resident, the facility must comply with these tags 22, 23, and 24, and the resident must be permitted to return and resume residence in the facility while an appeal is pending. There's just a lot of issues that I see with meeting this requirement, especially with the COVID. Not permitting a resident to return. If a facility does not permit a resident who went on therapeutic leave to return, the facility must meet the requirements for a facility-initiated discharge at tag F622. Because the facility, this is critical, because the facility was able to care for the resident prior to the therapeutic leave, documentation related to the basis for the discharge must clearly show why the facility can no longer care for the resident. If the facility determines that the resident will not be returning, they must notify the resident and the ombudsman in writing of the discharge, including notification of appeal rights. If the resident chooses to appeal the discharge, the facility must allow the resident to return to the room unless there is evidence that the resident's return would endanger the health or safety of the resident or other individuals in the facility. And that goes back to those 6 criteria for the facility-initiated discharges. So let's look at the waivers. And these are important. I think one of the things that we have looked at and what Team TSI did is we went back and we took those waivers and we crosswalked the waivers to the tag number and what they affected. So what I want to look at, excuse me, is transfer and discharges. CMS is waiving requirements, all these requirements, with some exception, to allow a facility to transfer or discharge residents to another facility, another long-term care facility, solely for the following cohorting purposes. And they list, there's 3 of them. So I encourage you to look at those 3: transferring residents with symptoms, transferring residents without symptoms, and transferring residents where the facility agrees to accept specific residents for observation. So those are the 3 criteria. Notice that it says this: these requirements are only waived in cases where the transferring facility receives confirmation that the receiving facility agrees to accept the resident to be transferred or discharged. Confirmation may be in writing or verbal. If verbal, the transferring facility needs to document the date, the time, and the person that the receiving facility communicated agreement. So those are the 3 basic reasons. Now, they waive some requirements, and let's look at those. Exceptions to the transfer and discharge notices. So what we did with this, we went back to all of those CFR reference numbers that they had, that we just looked at on the previous slide. And what are those? CMS is only waiving the requirement under C5 that a facility provide advance notification of options relating to transfer or discharge to another facility. Notice this statement. Otherwise, all requirements related to 48310 resident rights are not waived. So what are they waiving here? The right to be informed in advance, tag number 552. So what we did is we took all of those references and identified the tag. Now, it's important to note, and Greg mentioned this earlier, this waiver is only specific to 48310C5. Only part of 48310 is waived is tag 552, and only that part. which the right to be informed in advance. So all of those notice requirements of 30 days, 24 hours, those are waived, but you still must provide the information. You don't have to provide it in advance, but you still must provide it. Also, CMS is only waiving the requirements under 4315C3 and all of these numbers for the written notice of transfer or discharge to be provided before the transfer. This notice must be provided as soon as practical. So what are these tag numbers? Well, over here we've identified them. We're looking at tag 623, 625, and these, we'll look at those. But these are the numbers within these sections that are waived. The notice before transfer, the timing of the notice, the reason for the transfer or the discharge, the name and address and phone number of the ombudsman, the notice of bed hold policy. So all of these are waived, but the notice must still be provided. It doesn't eliminate your providing the notice. It only is waiving the requirement that you have to provide it in advance. It's also only waiving the time frame for certain care planning requirements for residents who are transferred or discharged for the purposes explained in number 1 and 3 above. And that was the previous slide where we looked at those 3 criteria. These deal with tag number 655, which is the baseline care plan, the comprehensive care plan in place of the baseline, the comprehensive care plan within 7 days. So these tags are waived as far as the time frame. Notice that's the only thing in this regulation that's waived. So we want to be sure that we are focused with what those requirements are. Now there's other things here that you look at. Receiving facilities should complete the required care plans as soon as practical. CMS expects receiving facilities to review and use the care plans for residents from the transferring facility and adjust as necessary to protect the health and safety of the residents. These requirements are also waived when transferring residents to another facility, such as a COVID. So be sure that you take some time to study these waivers. And we've provided you with the information on what tag numbers that are affected, and just these sections are affected. Discharge planning. So when you look at the discharge planning, it's waiving the discharge planning requirement, which requires the facility to assist residents and their representative in selecting a post-acute care plan. This tag number 660. Assisting residents in selecting a post-acute provider by using data that includes but is not limited to assessment data, quality measures, and available resources. What that means is, under tag number 660, if you transfer a resident or discharge a resident to another facility, to a home health, another long-term care facility, long-term care hospital, there's inpatient rehabilitation facility. If you transfer those residents to these places, you are required to provide the resident and the family with information about the facility's quality measures relative to what their discharge goals are. For example, if a resident is being discharged and they have issues with pressure sores, they are being transferred to a facility in another state or another county, and that facility's quality measures indicate that they have issues with skin care, then you have to provide that information to that resident, to that family. Now, that doesn't mean anything to them. You just have to provide it to them. They can still decide to go, but you are required to do that. That waiver has been, this is waived, and that's a blessing to waive that, because that's a lot of information that you have to provide, and the regulations at 660 require you to explain that to them. You have to explain what those quality measures mean, and that's difficult sometimes. We have a hard time understanding it. They are maintaining all other discharge planning requirements. They are maintaining all other discharge requirements. So I encourage you, when you print this out and look at it, look at what these waivers do not affect the following things. So you'll have an opportunity to look at that. Use of the discharge and hospitalization CE pathways and care area probes. They are looking at these questions. They're going to ask you they're asking the resident, as a matter of fact, and the family, and they're looking at the medical record as well. If they are not met, they're going to cite tag 623, and they're also looking at these things as well. Same thing with residents being discharged after hospitalization. That's a facility-initiated discharge, and these are the things that they're going to ask. They will ask and answer every one of these questions before they leave the facility. They must do that, and they're asked to look at these things as well. But focus here and here when you're looking at these. The resident interview, these care area probes. The care area is hospitalizations, and all three of them are in resident interview, they are in the resident representative interview, and they are in the record review, and these are the questions that they will ask. There's one other point I want to make. MDS discrepancy is in all three of them. That is critical, because what the surveyor team does prior to coming into your facility, they run what's called a MDS facility rate indicator report. They will find residents who have triggered hospitalizations. Hospitalization is one of the 32 areas that they look at. Because it's an MDS discrepancy, they're going to look at the MDS and the care plan carefully when they're identifying these issues. I know we went through a lot, but it's all of the information that you have that you need is certainly available to you in the handouts. Dolly, I'm sorry I ran over, but a lot of information to cover.
No, that was perfect. Thank you so much, you. And we are all here. There's everyone's hanging in there because this is just so great. I did have just a couple questions. Those of you that are maybe thinking of a question as you're digesting all this great information, please feel free to type those in now. But the two questions I have are, would surveyors go to see previous residents to assess the psychosocial effects of transfers? It would seem like they couldn't access that if they didn't.
Oh, that's a great question. I think one of the requirements in the survey process is to review the discharge records. They're going to look at least 2 to 3 discharge records. So it's highly likely that they could look at that, and they may contact them. I'm not aware of them doing that, but Greg, Pat may have information on that.
I think most of that generally occurs as a phone contact when the surveyors, they're not going to probably go out and physically visit, but they'll have phone, either have a phone contact when they're back in the field office. That's what you see more with complaints and investigations related to abuse and neglect when families are discharged residents. So yes, that's what I would expect to see.
Perfect, thank you. So the next question is, does the information pertain to long-term care residents only, or does it also apply to short-term rehab residents?
I don't believe length of time in the facility matters in response to transfer and discharge. If you're a resident, the regulation applies.
I agree.
Thank you. And I do have another question that's coming in here. Let's see. Can you speak to evacuation because of the pandemic for notice requirements and MDS requirements? My understanding is that as long as the resident returns within 30 days, the transferring facility will continue assessments upon return as if they never left.
I believe that's correct. I know that if they're being discharged to another facility expecting to return, then that facility continues to bill as well. In fact, that's in one of the I think it's in one of the slides. I think it's on one of the transfer slides. I think that information is there as well. But based on current information that the survey team has released, or CMS has released, is that evacuation, because of the public health emergency, if you implemented your emergency preparedness plan during this public health emergency, you are not going to have to do a drill, a disaster drill for a year. However, you still must do the tabletop exercise for this year.
Wonderful, thank you. Okay, well that covers all of the outstanding questions. We were able to answer all of the others. So Hugh, thank you so much. I really appreciate this expert training today. And if there's anyone that has any other questions, please feel free to reach out to support@teamtsi.com and they'll get it over to us and we'll get that answered for you.
Thank you.
So
I
thank you,
enjoyed it. I know we covered a lot of material, but sometimes we have to do it like that.
Thank you so much, Hugh.
Thank you. Guys, have a great day.
Thank you. Bye-bye.